Great, good morning. Again, my name is Jim Bassett, class of 78. I'm the chairman of the planning committee for the bicentennial celebration of the Dartmouth College case, and I welcome you, hopefully many of you back. Some of you may have missed yesterday, but this is day 2 of the symposium. I hope you enjoyed yesterday as much as those of us that participated in it enjoyed the events of yesterday, and we hope that you will also enjoy today. I'm quite sure you will. 2 brief things. I feel compelled to correct the record yesterday when I spoke about my time floating down the river during the summer of 1976. I conflated 2 courses, and maybe I had tried to put it out of my mind, but Don Pease reminded me that the books that he made me read were Moby Dick. So it was clearly, had I had those books with me in the river, I would not be here today. So in any event, Don, the course I had with him was an American literature course, and it was great. And I believe, have that copy of Moby Dick in my library at home. So fortunately for you and me, my time up here today will be very brief. 2 things. I want to also recommend that sometime you make it over to Webster Hall and to the special exhibit that they've put together over there. There's some wonderful papers that the college has that are on display, and also there are the 4 portraits of the 4 lawyers that represented Dartmouth in the Dartmouth College case, a number of whom I referred to yesterday, Jeremiah Mason and Jeremiah Smith, who were the original lawyers for the college, brought in Daniel Webster, and then Webster and Hopkinson, who argued the case at the U.S. Supreme Court. Those are 4 portraits that were commissioned shortly after the case was decided by the U.S. Supreme Court in honor and to recognize those 4 men for the critical role that they played. They're great portraits, and I think the exhibit combined with looking at the portraits will have a significant impact on you. And finally, my role is to introduce John Graby, who you met yesterday. John's a great friend of mine and a law professor at UNH Law School in Concord. He's also the director of the Warren B. Rudman Center at the law school. And I would just say that, as I explained, it was about 2 years ago that Martha Beatty and Don Pease reached out to me to begin the planning process for this, and I had some ideas, but I had no idea how to put together a symposium. So I called John, and John has been the moving force going forward, particularly in the presentations today. And John and Kate Stith and Ernie Young were a great team to work with, and without John's leadership and able assistance, none of this would have happened. So with that, I'd like to introduce John. And thanks very much for coming.
Thank you, Jim, and good morning, everybody. And thanks for those kind words. I really have to credit Ernie and Kate for all the help in putting together the wonderful panels that we're going to be hearing from today. So I don't want to cut into panel time, so I'm just going to give you a little overview of the day. We have 4 events planned for today. The first panel, which will be taking place in a minute here, is titled From the Contract Clause to Due Process. The second panel, which will follow, is titled The American University, Public and Private. Both panels will feature preeminent constitutional law and constitutional history scholars who will be talking about the impact of the case on subsequent developments in the law. Following the second panel, we will have a reception and networking event. At the conclusion of that, we will have a panel on Supreme Court practice then and now, featuring the advocates from yesterday. And the day will conclude with Tom Burek, class of 1982, performing Daniel Webster's famous peroration. So at this point, I'd like to turn things over to Professor Annette Gordon-Reed from Harvard Law School, and look forward to the day. Thank you.
Thank you very much. I've changed a bit. I'm going to sit here and introduce them instead of standing at the podium, and they're going to present from the podium. We're going to have a lively discussion, I hope, with questions afterwards, and so I've kept the introductions brief. First, Caleb Nelson, who is the Emerson G. Spies Distinguished Professor of Law at the University of Virginia School of Law. He specializes in constitutional law, federal courts, and legislation, and I also believe he teaches civil procedure.
I do.
That's right. Then we will have Akhil Amar, who is the Sterling Professor of Law and Political Science at Yale University, where he teaches, of course, constitutional law. And then we have Ernest A. Young, Alston and Byrd Professor at Duke Law School. He teaches constitutional law and federal courts, and he's an expert on federalism. So Caleb will start us off, and we will go in order of my introduction.
Thank you very much. Thank you for having me. I'm honored to be at the symposium. It's a particular pleasure to be here with two of my favorite professors from law school, Kate Stith-Gerbanis and Akhil Amar. Way back in the day when I was applying for academic jobs myself, they were two of the three professors who served as references for me.
Oh, wow.
And the fact that I did get a job leads me to believe that their remarkable generosity overcame their natural candor. So I have always been grateful, but it is an honor to be at the symposium. The title of our panel, From the Contract Clause to Due Process, invites us to talk about shifts in constitutional doctrine, and particularly shifts in doctrine about constitutional restrictions on the powers of state legislatures. Of course, until the Reconstruction Amendments were ratified, the federal Constitution didn't contain many explicit restrictions on the states. The original Constitution was mostly about the federal government, not the states. But Article 1, Section 10, did list a few things that states can't do. One of the things in that list is the Contract Clause, which says that no state shall pass any law impairing the obligation of contracts. Partly because that's an important but ambiguously worded principle, and partly because the original Constitution didn't contain many other explicit restrictions on the states, the Contract Clause was the focus of a lot of litigation in the 19th century. According to a classic book by Benjamin Wright, the Contract Clause came up in almost 40% of the cases in which the Supreme Court heard constitutional challenges to state legislation for the first century of the court's operation, that is from 1789 to 1889, and it was the basis for decision in 75 of the cases from that period in which the Supreme Court held that a state law was unconstitutional, which is nearly half of the cases in which the Supreme Court reached that conclusion in that period. But after the Civil War, litigants who wanted to challenge state laws had some other constitutional provisions to invoke. One of those new provisions was the Due Process Clause of the 14th Amendment, which had been ratified in 1868, and the Due Process Clause forbids states to deprive any person of life, liberty, or property without due process of law. During the so-called Lochner era, which ran from about 1890 to the 1930s, the Due Process Clause supplanted the Contract Clause as a focus of constitutional challenges to certain kinds of state laws. And when the Lochner era was ending, some of the ideas that contributed to its demise also led to reinterpretation of the Contract Clause, with the result that the Contract Clause never really regained its former importance. Because we're here to mark the 200th anniversary of the Dartmouth College case, I want to talk about where that case fits into this story. The Dartmouth College case was partly responsible for the importance of the Contract Clause in the 19th century, but with the benefit of hindsight, we can also see some features of Contract Clause doctrine that may have contributed to the eventual shift to the Due Process Clause. To appreciate the initial significance of the Dartmouth College case, we need to understand what it added to pre-existing doctrine. And to do that, we have to start with the earlier case of Fletcher against Peck. In 1795, the legislature of the state of Georgia had enacted a statute selling 4 huge tracts of public land to 4 private companies for a total of $500,000. Technically speaking, the statute didn't itself grant the land, but it authorized the governor and directed the governor to do so upon proof that the first installment of the purchase price had been paid. The purchasers did indeed pay the money, and the governor granted the land. But soon it emerged that legislators had been bribed to enact this statute, and the voters threw the bums out at the next election. In 1796, the new legislators enacted a new statute purporting to declare that the earlier statute was null and void, that the grants derived from it were also void, and that the land described in the earlier statute belonged to the state. But in Fletcher against Peck, the Supreme Court held that this new statute violated the Contract Clause. According to Chief Justice Marshall, the earlier statute amounted to a contract, not so much the bribe, but the statute itself amounted to a contract, that was performed when the governor granted the land. And the grant itself implied a contract not to reassert ownership. Of course, parties sometimes can obtain rescission of a contract by proving fraud in court. And the state of Georgia could have brought a lawsuit trying to unwind the sale on that basis, subject to the need to protect innocent third-party purchasers. But the legislature couldn't just enact a statute, making its own findings of fraud and authoritatively declaring that the land still belonged to the state. Fletcher against Peck established that the Contract Clause applies not only to purely private contracts, but also to contracts between private parties and the state itself. Fletcher also established that a statute enacted by the state legislature could sometimes give rise to such a contract, and if it did, the Contract Clause would limit the state legislature's power to repeal that statute. Still, the contract at issue in Fletcher against Peck was the sort of contract that could be made between private parties, a sales contract about the transfer of land upon payment of the purchase price. In the Dartmouth College case, the Supreme Court went a step farther. The contract at issue in the Dartmouth College case was not the sort of contract that private parties make between themselves. Instead, the contract was the charter that the Crown had issued to establish the Trustees of Dartmouth College as a corporate body and to give the corporation its powers and its legal capacity. Without necessarily saying that corporate charters always amounted to contracts, Chief Justice Marshall held that this one did. Indeed, quote, "It can require no argument to prove that the circumstances of this case constitute a contract," he wrote. "An application is made to the Crown for a charter to incorporate a religious and literary institution. In the application, it is stated that large contributions have been made for the object, which will be conferred on the corporation as soon as it shall be created. The charter is granted, and on its faith the property is conveyed. Surely, in this transaction, every ingredient of a complete and legitimate contract can be found." You might think that's an aggressive interpretation of what count as contracts within the meaning of the Contract Clause. The immediate motivation for including the Contract Clause in the Constitution may have been the debtor relief laws that various states had enacted during and after the Revolutionary War, and those laws acted upon what Professor Stephen Siegel has called ordinary contracts, like contracts pursuant to which people had borrowed money or bought goods on credit. In the 1780s, many people were having trouble paying their debts. To help them out, a number of state legislatures enacted laws that operated upon pre-existing contracts and prevented courts from enforcing those contracts according to their terms. At the time of the founding, those laws may have been the paradigmatic examples of laws impairing the obligation of contracts. On the other hand, the framers might have had more than one set of examples in mind. Some scholars point to an incident in the 1780s involving the Bank of North America, which had been chartered by Congress in 1781 and by the Pennsylvania legislature in 1782. In 1785, the Pennsylvania legislature repealed the charter that it had enacted 3 years earlier. At the time, James Wilson argued that the charter amounted to a compact that the Pennsylvania legislature couldn't unilaterally terminate. Because Wilson went on to be a prominent member of the Philadelphia Convention, Some lawyers and law professors have concluded that the contract clause was specifically intended to encompass corporate charters as well as ordinary contracts. And even if the framers were not specifically thinking about corporate charters, the general rule that the contract clause established could certainly extend beyond the paradigmatic examples that they had in mind. Anyway, whether the framers envisioned the specific application of the contract clause to corporate charters or not, Professor Siegel reports that Chief Justice Marshall's opinion in the Dartmouth College case was not controversial in its day. Going forward, the idea that a charter issued by the state amounted to a contract within the meaning of the contract clause didn't necessarily hamstring the states, because states were in charge of what the charters that they issued said. Even before the Dartmouth College case, a number of states had started including so-called reservation clauses in their charters, clauses saying that the state reserved the power to rescind or modify the charter later on. In his concurring opinion in the Dartmouth College case, Justice Story implied that if Dartmouth's charter had included such a clause, then the state could have modified the charter without violating the contract clause, because that possibility would have been part of the original deal. By the same token, the Supreme Court eventually held that the contracts clause, that contracts create only the obligations that they can create under the law that exists at the time that the contract is made. If somebody borrowed money under a contract that required him to pay it back, the contract clause would prevent a state from later enacting a bankruptcy or an insolvency law that applied to this pre-existing contract and allowed the debt to be discharged without the creditor's consent. But the contract clause did not prevent states from enacting insolvency laws that applied to all contracts made after those laws were on the books. Once the insolvency law had been enacted, once the insolvency law was on the books, the possibility of a discharge under that law was built into whatever contracts people subsequently made. In keeping with that theory, many states enacted a standing law, either by statute or as part of their state constitution, saying that the state issued corporate charters subject to the possibility of subsequent repeal or modification. So they had effectively a general reservation clause as part of their standing law. Whatever charters the state issued from then on would be deemed to come with that limitation, and the contract clause wouldn't prevent the state from repealing them. The bottom line is that as interpreted by the Supreme Court, the contract clause was a rule against retroactive legislation. It prevented states from applying certain kinds of new statutes to pre-existing contracts, but it did not prevent states from enacting statutes that would operate with respect to all contracts made from then on. That fits with what the great political scientist Edward Corwin later described as the basic doctrine of American constitutional law before the Civil War, the doctrine of vested rights. Certain kinds of legal interests were said to be capable of vesting in private individuals or private entities in such a way that either the federal constitution or the various state constitutions would prevent the legislature from subsequently abrogating them. In particular, both contractual rights and rights to traditional forms of property were capable of vesting in that way. But the doctrines that determined whether such rights had vested were not thought to, they referred to the law that existed at the time of the contract being made, right? They existed, the doctrines that determined whether a right had vested referred to the law that existed at the time of the vesting. Provisions like the contract clause weren't thought to specify what that law had to be. So state legislatures could write their laws in such a way as to minimize the number of vested rights that came into existence. To the extent that states reacted to the Dartmouth College case by including reservation clauses in the charters that they issued, or by enacting a general reservation statute, states could retain power over corporate charters. Over time, that's what states did. A modern study by a lawyer named Ian Spire reports that nowadays every state except Utah has a reservation clause either in its state constitution or in its state corporation code, or both. The fact that the contract clause operated simply as an anti-retroactivity principle and did not prevent states from building these kinds of reservations into their standing laws may be one reason why constitutional litigation eventually shifted away from the contract clause and toward the Due Process Clause. To be sure, early interpretations of the Due Process Clause also emphasized a doctrine of vested rights. But during the Lochner era, the Due Process Clause came to be more than just an anti-retroactivity principle. In the words of Professor James Keenan, there was a shift from the doctrine of vested rights to doctrines of substantive rights, which prevented government from regulating people in certain ways without regard to when the regulations were adopted. That shift may have been easier to accomplish under the Due Process Clause than under the Contract Clause. Here's a second possible reason why, after the 14th Amendment was ratified, lawyers and judges eventually shifted their emphasis away from the Contract Clause and toward the Due Process Clause. The Contract Clause restricted states' lawmaking power only to the extent that there were pre-existing contracts to protect. After the Dartmouth College case, corporate charters were prominent examples of such contracts. But from the Jacksonian era on, many people did not like special protections for corporations. Eventually, doctrine under the Contract Clause, and specifically the Dartmouth College case and its progeny, came under attack for effectively giving corporations more constitutional protections than ordinary people. After Chief Justice Marshall died and President Jackson appointed Roger Taney to replace him, the Supreme Court started interpreting corporate charters strictly, so that any ambiguities in what the state had granted would be resolved against the corporation. That's the upshot of the famous Charles River Bridge case. But if a corporate charter unambiguously gave the corporation some sort of perpetual right or immunity without an applicable reservation, the Contract Clause was still understood to prevent a later state legislature from repealing it without the corporation's consent. In practice, that aspect of constitutional doctrine benefited corporations more than it benefited ordinary people, because ordinary people don't get charters from the state. That irritated Jacksonians. In the 1850s, the Ohio Supreme Court complained, quote, "The whole doctrine of vested rights has for its object the establishment of the rights and property of corporations upon a footing of far greater sanctity and permanency than the rights and property of private persons, by placing them beyond the reach of the lawmaking power of the state." The flashpoint for that complaint involved exemptions from state and local taxes. In 1845, the Ohio State Legislature had created a statute that allowed banks to become corporations and to pay 6% of their profits to the state in lieu of all taxes to which they otherwise would be subject. After some banking companies had been established under that statute, a new crop of legislators tried to change the law. The legislature enacted a statute subjecting banks to the state's normal property taxes. Ultimately, the federal Supreme Court held that this new statute was unconstitutional as applied to the banking companies that had been formed in the interim, the banking companies that had been created while the old statute was in place. So the state had made a contract with those banks, exempting them from ordinary taxation, and the Contract Clause prevented the state from rescinding that exemption by statute. That conclusion grew out of the Dartmouth College case, as well as some other decisions, but it made the Dartmouth College case more controversial than it initially had been. In the 1850s, the Ohio Supreme Court refused to treat the US Supreme Court's decisions in the tax cases as binding precedents. More generally, Professor Herbert Hovenkamp has called attention to the following passage in the 1871 edition of Thomas Cooley's treatise on constitutional limitations on the state's legislative powers. Here's what Cooley said, quote, "It is under the protection of the decision in the Dartmouth College case that the most enormous and threatening powers in our country have been created, some of the great and wealthy corporations actually having greater influence in the country at large and upon the legislation of this country than the states to which they owe their corporate existence. Every privilege granted or right conferred being made inviolable by the Constitution, the government is frequently found stripped of its authority in very important particulars by unwise, careless, or corrupt legislation. To guard against such calamities in the future, it is customary now for the people in framing their constitutions to forbid the granting of corporate powers except subject to amendment and repeal. But the improvident grants of an early day are beyond their reach." Likewise, an article about the Dartmouth College case published in the American Law Review in 1874 referred to, quote, the murmuring at the entire doctrine, which is beginning to be heard throughout the country, the restless, fitful desire to get rid of it, which large classes of people begin to feel. Along the same lines, a treatise that Francis Wharton published in 1884 asserted that, quote, there is a growing tendency to doubt the correctness of the general rule laid down in the Dartmouth College case, so far as it involves the assertion that a state cannot recall a franchise granted to a private corporation or modify grants made to such a corporation. Professor Hovenkamp links concerns about special privileges for corporations with changes in conceptions of the corporation itself. At the start of the 19th century, each corporation, in Hovenkamp's words, was, quote, created by the state for a special purpose and enjoyed a privileged relationship with the sovereign. But by the middle of the 19th century, the corporation was seen as a standard type of business organization, and many economists thought that corporations should not receive special subsidies or benefits. As that shift took hold, the typical corporation no longer got a special charter from the state. Instead, states enacted general incorporation laws that enabled people to form corporations on their own, pursuant to these general statutes. As Professor Hovenkamp suggests, these evolving views about the corporation probably contributed to the shift from the Contract Clause to the Due Process Clause. Even among justices who were inclined to read the Constitution as protecting economic rights, there wasn't much support for giving corporations special protections, as doctrines associated with the Dartmouth College case effectively did. Once the Due Process Clause became available as an additional source of constitutional protections for property and other economic rights, it offered the court a way to protect those rights for individuals and partnerships, as well as for corporations. In the 1930s, of course, a majority of the justices wanted to rethink doctrine about constitutional protection for economic rights. But there was no reason for those justices to shift back to emphasizing the Contract Clause. They didn't want the Contract Clause to restrict state policymaking any more than they wanted the Due Process Clause to do so. So in 1934, the same year that the majority opinion in Nebbia against New York upheld price control legislation that previously would have been thought to violate the Due Process Clause, in 1934, the majority opinion in Home Building and Loan Association against Bladesburg upheld debt relief legislation that previously might have been thought to violate the Contract Clause. Both cases were 5-4 decisions, with the same 5 justices in the majority and the same 4 justices in the dissent. So here's the general arc of the Contract Clause. In the first few decades of the 19th century, the Marshall Court interpreted the clause expansively, and the Dartmouth College case is part of that story. In the second half of the 19th century, the Dartmouth College case came under fire for effectively giving special protections to corporations, and lawyers and judges started to shift their emphasis toward the Due Process Clause. The fact that the Contract Clause simply protected vested rights, and the Due Process Clause eventually came to be understood to do more than that, was an additional reason for the shift. But in the 1930s, a new set of justices reinterpreted both the Due Process Clause and the Contract Clause in such a way as to give state legislatures more flexibility. A generation later, in the 1960s and 1970s, the concept of substantive due process was revived in the realm of non-economic rights, but not so much in the realm of economic rights, and the Contract Clause has never regained its former prominence.
I'm deeply grateful for the chance to speak with you all at this extraordinary symposium, marking the bicentennial of the justly renowned decision, Dartmouth College v. Woodward, here at the very place that was the beating heart of the case, the scene of the crime, so to speak. In what follows, I will try to be on my best behavior for several reasons. First, whereas many of my distinguished colleagues at this symposium have intense and lifelong connections to this special school, I spent my bright college years somewhere else. This is an away game for me, And when in Hanover, a visiting Yalie should mind his manners. Second, many of my closest friends have been shaped by this place, and I want to do them proud. I'm thinking in particular of my dear colleague and neighbor, Kate Stith Cabranes, my pastor and her family, the Latimers, two of my wisest and most inspiring teachers at Yale Law School, Owen Fiss and the late Joseph Goldstein, and of course, my de facto kid brother, we've informally adopted each other, Neil Katyal, who both literally and figuratively stands in Daniel Webster's shoes these days as America's preeminent Supreme Court litigator. Third, I have twin daughters, Kara and Sarah Amar, who've applied this year for admission to Dartmouth College and are anxiously waiting to hear back later this month. When they learned, to their horror, that I would be speaking here, they jointly and severally admonished me not to embarrass them or besmirch the family name. If I screw up today, there will be hell to pay at home. I propose to consider the Dartmouth College case alongside two other landmark decisions, one handed down 9 years earlier and the other rendered 14 years later. Ask any constitutional historian or any constitutional law professor, or better still, consult the twin oracles of all truth, Google and Wikipedia, and you will be assured that Fletcher v. Peck, 1810, Dartmouth College v. Woodward, 1819, and Barron v. Baltimore, 1833, rank among the most notable Marshall Court opinions of all time, alongside a handful of other classics such as Marbury v. Madison, Martin v. Hunter's Lessee, McCulloch v. Maryland, Gibbons v. Ogden, and Worcester v. Georgia. In Fletcher, 1810, Chief Justice Marshall ruled that the Georgia government, having contracted to sell a vast tract of land at suspiciously low prices to shady speculators, could not constitutionally take the land back by mere legislative decree. No takebacks. Why not? Because of the Contracts Clause, the Article 1, Section 10 clause prohibiting states from, quote, impairing the obligation of contract. And you've heard all about that from Caleb. A clause that Marshall held in Fletcher applied not just to contracts entered into between two private parties, but also to contracts made by the state itself, as Caleb has told you. In the Dartmouth College case, Marshall built on Fletcher's foundation, having in effect contracted to charter Dartmouth College as a private, independent educational entity. New Hampshire couldn't constitutionally take the charter back or rejigger it by mere legislative decree. No takebacks. Why not? Once again, because of the Contract Clause and the logic of Fletcher, which applied not just to land, but to intangibles such as the Dartmouth Corporate Charter, vesting the Dartmouth trustees with myriad and detailed rights and privileges that the state was not free to abrogate willy-nilly. So far, so good. But now consider the third case, Barron v. Baltimore, in which Marshall held that the first 10 amendments to the U.S. Constitution, what we today call the Bill of Rights, applied only against the federal government and not the states. The particular clause of the Bill of Rights at issue in Barron was the Fifth Amendment's Takings Clause, also known as Just Compensation Clause, which says that, quote, private property shall not be taken for public use without just compensation, unquote. States and localities, Maryland and Baltimore, in the case at bar, were free, said Marshall, to expropriate private property for public purposes without any federal obligation to pay for the expropriated property. All three cases, Fletcher, Dartmouth, and Barron, are classics. All three are generally today seen as solid decisions, at least strongly plausible, at best self-evidently correct. But you see the problem, right? The tension? Why doesn't the Barron case undo all the protection that the Dartmouth case seemed to offer? After Barron, in, say, 1834, on the 15th anniversary of the Dartmouth case, what would have stopped the New Hampshire legislature from expropriating Dartmouth College directly? Not by trying again, as the state had tried earlier and failed, thanks to Chief Justice Marshall, to revoke or modify Dartmouth's ancient charter, but rather by more ruthlessly expropriating everything, the land, the buildings, the name, the charter, the trademark, the goodwill, in short, the franchise, in one swoop, without so much as a penny of compensation, in keeping with Barron's holding that the Just Compensation Clause of the original Bill of Rights did not apply to state governments. One possible answer is that the cases are indeed in irreconcilable tension, that Marshall goofed in the Dartmouth College case and the earlier Fletcher case, and that he later properly corrected his error in the Barron case. I admit that in a footnote back in 1987, I floated the idea that perhaps Marshall in the Fletcher case and also in the Dartmouth College case read the contract clause too expansively when he decided that the clause applied not just to situations where the state retroactively disputed contracts between two private parties, A and B, but also in situations where the state was trying to weasel out of a contract in which the state itself was a contractual party. This position, which I floated in this 1987 footnote, is not preposterous. But today, of all days, and here, of all places, it ill behooves me to suggest that the Dartmouth College case was in any respect wrongly decided. This is not the sort of high-sticking move that a well-behaved visiting Yale should try here in Hanover. And if word gets out to any Dartmouth admissions officer that I badmouth Daniel Webster's greatest judicial victory in a case that's the stuff of Dartmouth legend, a case about Dartmouth's very right to exist, my twins will not be amused. So let's move on quickly to consider other possible ways of addressing the seeming tension between these classic Marshall Court opinions. One approach would say that Fletcher and Dartmouth College decisions are basically right, but that Marshall goofed in the later Barron case. Can it really be true that the federal Constitution prior to the Civil War allowed states to grab private property willy-nilly with no robust protection from federal judges? Actually, it was true. As Marshall carefully explained in Barron, the first set of amendments to the U.S. Constitution had been introduced at the prompting of states' rightists, anti-federalists, who feared Tea Party types of a certain sort, localists, who feared the emergence of an unduly powerful federal leviathan. This would never happen, of course. For a federal court to use this anti-federalist inspired state set of amendments against the states themselves would have turned the states' rights vision on its head. We can see the states' right lineage if we ponder the last of these early amendments, the 10th Amendment, explicitly affirming powers reserved to the states, respectively. But we can also see the states' rights vision in the opening strands of the First Amendment. That amendment explicitly says that, quote, Congress shall make no law respecting the establishment of religion or abridging the freedom of speech or of the press, unquote. But it says nothing about state establishments or abridgments. States in 1789, when the Bill of Rights was proposed, and 1791, when it was ratified, were thus free to have established churches. And in the founding era, roughly half the states did indeed have state government-supported churches. Consider, for example, Dartmouth's home state, the state where we're now gathered. When the First Amendment was drafted and ratified, New Hampshire had firmly in place a long-standing system of local religious establishments. The First Amendment did not undo New Hampshire's establishment system, nor did the amendment undo the establishment systems in other states and localities. If anything, the original First Amendment protected these state establishments from federal interference. Congress could not enact an established national church, but neither could Congress enact a law disestablishing, say, New Hampshire's church system. This congressional disestablishing statute would be a law respecting, a law regarding, a law on the topic of establishment. And the entire topic of church-state policy was declared off-limits to Congress by the First Amendment itself. In effect, the First Amendment said, Congress, make no law on the topic. Congress, butt out. When ratifying the U.S. Constitution in 1788, a special convention of New Hampshiremen had put the point this way, quote, Congress shall make no law touching religion, unquote. Phraseology that New Hampshire Congressman Samuel Livermore later proposed in the first Congress itself. The states' rights vision underlying this proposal found its way into the final vision of our First Amendment via the word respecting in lieu of touching. In this respect, the First Amendment was rather like the 10th Amendment, telling the feds to allow certain things to be decided at the state and local level. Put differently, the First Amendment, as originally understood, was akin to the 1555 European Peace of Augsburg and the 1648 Treaty of Westphalia, in which church-state policy in Central Europe was to be decided at the local level and not the imperial level. The religious policies of individual local princes would govern their respective principalities, in the famous Latin phrase, cuius regio eius religio. This patchwork solution had helped keep the peace in Central Europe, and it offered a template for antebellum America, where rather different religious patterns and rather different church-state policies operated in different parts of the continent. Congregationalists held sway here in New England, Anglicans dominated down south, Quakers clustered in Pennsylvania, Catholics sought refuge in Maryland, some free thinkers flocked to Rhode Island, and Congress as a whole butted out. This antebellum legal world, I hasten to remind you, was swept away, and rightly so, by the Civil War and the Reconstruction amendments that ensued. Whereas the First Amendment said that Congress shall make no law abridging certain basic rights, the 14th Amendment says, quote, no state shall make or enforce any law which shall abridge, unquote, certain fundamental rights, including rights of religious liberty and religious equality. Today, states are not allowed to abridge speech or press or to suppress one religion or favor another religion. Some of the words of the First and 14th Amendments are the same: shall, make, no, law, abridge. But now these words limit not Congress but states, and of course localities, which are state creatures. The American Revolution had pitted local governments, local militias, local juries, local churches, local legislatures against the central British imperial government. Han Solo and Luke Skywalker against a sort of an evil empire, okay? And the original Bill of Rights reflects this revolutionary localism. Barron was right. The original Bill of Rights, inspired in large part by anti-federal states' rightists, does not properly apply against states, but only against the federal government. While the First Amendment explicitly limited its focus to the federal government, Congress, that's explicit, the federal focus was merely implicit, albeit strongly so, in all the other amendments and clauses, including the Fifth Amendment Just Compensation Clause at issue in Barron. Today, however, we stand in the shadow not just of the Revolution of 1776, but of the Civil War, a war in which the seceding states had misbehaved by taking up arms against a duly elected government. In the aftermath of that war, the 14th Amendment sensibly proclaimed that states must be limited, that America must have a second Bill of Rights, in effect a Bill of Rights limiting state and local governments and not just the federal government. So, Barron was rightly decided in 1833. The original Bill of Rights was designed to limit the feds and only the feds. The Reconstruction generation intentionally overruled Barron via the 14th Amendment so that today states must, of course, protect free speech and religious equality and, of course, the right to be paid just compensation if any government, state or federal, tries to take one's private property for public use. But to repeat, this was not the rule in 1833, and Marshall was right to insist that the original Bill of Rights did not prevent a state from grabbing private property willy-nilly. So Barron was right, and so let us stipulate was the Dartmouth College case, but how are these landmark Marshall decisions to be reconciled? Chief Justice Marshall, meet Chief Justice Marshall. Dartmouth College in 1819 had squarely built, as Caleb said, on the 1810 case of Fletcher versus Peck, in which Marshall had described Article 1, Section 10, which includes the Contract Clause, and lists various things that states may not do to their own citizens as, quote, this is Marshall language, a Bill of Rights for the people of each state, unquote. But didn't Barron in 1833 wash almost all this away when it allowed states to violate the just compensation principle and most of the other principles set out in the first 8 amendments, which today's Americans view as the real Bill of Rights? Or to restate the puzzle, once again in a more pointed way, why couldn't New Hampshire, following Barron and despite Dartmouth College, just grabbed everything in sight, all things Dartmouth, in, say, 1834? Before I give you my best answer to this puzzle, let me mention one more thing by way of a detour and parenthesis about the First Amendment and the original Establishment Clause. Today, almost all the big Supreme Court cases that we call First Amendment Establishment Clause cases are in fact nothing of the sort. They do not involve Congress. They do not involve the federal government. They involve state and local government policies. They thus trigger the 14th Amendment's rule that no state shall make or enforce any law that shall abridge basic rights like the right of free speech and religious equality. Now, the title of this panel is Due Process, but I'm focusing on the adjoining language of the 14th Amendment for some technical legal reasons, because they echo the language of the First Amendment: shall, may, no, law, abridge. Consider, for example, this term's biggest supposed Establishment Clause case. The case argued just this week at the Supreme Court involves the Bladensburg Cross in Maryland, the very state that gave us Barron v. Baltimore. But despite what you may have read in the press or seen on television, the case, strictly speaking, is not an Establishment Clause case. It involves Maryland's policy, not Congress's. And Maryland's policies were this week brilliantly defended by, who else? A Dartmouth man, today's Daniel Webster, our very own Neil Caddell. Okay, now back to our puzzle. What would have stopped New Hampshire from grabbing everything in 1834? One possible answer is the New Hampshire state constitution. Even if, thanks to Barron, the federal Fifth Amendment didn't apply against the states, surely the state constitution did guarantee New Hampshiremen various rights against the state. According to Article 12 of the New Hampshire Bill of Rights of 1792, quote, "No part of a man's property shall be taken from him or applied to public uses without his own consent or that of the representative body of the people," unquote. But this state constitutional clause is not nearly so emphatic and protective as the Fifth Amendment's rules against Congress, which today, thanks to the 14th Amendment, apply fully against states and localities. The New Hampshire words do not require just compensation. They don't require payment. They seem to leave private property to the tender mercies of the New Hampshire legislature, a representative body of the people. But what if Dartmouth's enemies outnumber and outvote Dartmouth's friends in the New Hampshire legislature? And could Dartmouth rest easy, relying entirely on New Hampshire state judges? Let's recall that the state bench, whose members were, of course, picked and paid by the New Hampshire government itself, had not been particularly stalwart in the Dartmouth College versus Woodward case itself. Here, then, is my final proposed reconciliation. Perhaps New Hampshire could have taken all sorts of private property from all sorts of persons and entities in 1834, including Dartmouth, and the Supreme Court would not have intervened. Barron. But New Hampshire could not take back any property that had previously been conveyed by New Hampshire itself via contract. No takebacks. So if Dartmouth had tried to expand dramatically in 1834, buying vast tracts of new property in New Hampshire, the state might have perhaps tried to grab these newly purchased lands from Dartmouth and might have succeeded in this evil expropriation. The no take-back idea would not have come into play. Imagine, for example, that New Hampshire had in the 1790s conveyed a large plot of land to person X, who sold it immediately to person Y, who then conveyed it to person Z, who then sold it to Dartmouth in 1834. Here, and then New Hampshire tries to grab it from Dartmouth. Here, New Hampshire might say, "We have fully honored our contract with X. X indeed sold the land for full and fair value long ago. In fact, X is no longer even alive. Our contract for this plot of land was with X and not with Dartmouth. We have not taken back anything from X. The Fletcher and Dartmouth College case do not apply. As for our efforts to take X's initial plot from Dartmouth, the college is, insofar as this plot is concerned, no different from any other property owner. Thus we can, thanks to the Barron case, expropriate this plot from Dartmouth, howsoever large and valuable, without just compensation." Or imagine that the land had never originated in a New Hampshire contract with X or anyone else. Imagine that Dartmouth had bought the land from A, who had acquired it, let's say, by adverse possession or something like that. Here, too, New Hampshire might just try to grab Dartmouth's newly purchased land, pointing to Barron. But what New Hampshire could not do, even after Barron, even in 1834, is take back anything that had been conveyed by the contract in 1769. No takebacks. The land that Dartmouth had received directly from the state would be protected, and so would the corporate charter itself, and the special rights and privileges contained therein. Thus, Dartmouth would also be entitled to keep, as a matter of contract, its internal governance system, its good name, its goodwill, its legendary trademark, its franchise. On this proposed reconciliation, Dartmouth's special contract rights gave it protection that other mere property owners in the Barron era lacked, special rights of special corporations, but only for Dartmouth's original campus footprint and other charter rights. Until more robust protections materialized thanks to the 14th Amendment and its overruling in Barron, Dartmouth might be obliged to remain, geographically at least, a small college, much smaller than various vast Midwestern land-grant universities. According to the infallible Google, Dartmouth's campus comprises roughly 250 acres. The University of Illinois' campus, by contrast, sprawls to about 10 square miles, 25 times the size of Dartmouth. So thanks to the intricate interplay of the Dartmouth College case and the Barron case, Dartmouth College in the antebellum era perhaps had reason to be cautious in acquiring vast new tracts of land from future private landowners, as opposed to from the state itself. Even today, long after the demise of Barron, and in an era where the college can indeed rely on federal courts and the federal constitution to protect its federal property rights to just compensation, it has remained, in certain utterly charming respects, a small college. But there are those who, well, you know the rest.
Well, I'm very grateful to be part of this celebration of the 200th anniversary of Dartmouth College versus Woodward. I first encountered that case in the Govey 60 course taught by Professor Vincent Starzinger, who embodied Dartmouth's commitment to extraordinary undergraduate teaching and inspired many of us to become lawyers. Much of what I have to say today, including not only the Dartmouth College case, but also the thoughts I'll offer on Tocqueville and civil society, I really owe to Professor Starzinger. The Dartmouth College versus Woodward held that a private college's charter was a contract, and that the state of New Hampshire's effort to alter that contract, the terms of that charter, impaired the obligation of the contract in violation of the Constitution's contract clause. As a matter of doctrine, Dartmouth College has relatively little significance today. Its specific holding is readily drafted around, as Professor Nilsson explained. Federal litigation in the contemporary setting under the Contracts Clause remains quite rare. So a plausible working title for these remarks would be, "It is an obscure case, but there are those who love it." But the Dartmouth College case remains important both for its broader legal implications, its broader legal significance, and for what it can tell us about the way the Constitution works. The Contract Clause provides that no state shall pass any law impairing the obligation of contracts. We generally think about this clause as an individual rights provision, and it is. When the framers worried about the tyranny of the majority, they tended to have foremost in mind not the tyranny of white slaveholders over black Americans or religious majorities oppressing dissenters, but rather populist appeals to try to oppress creditors by passing debtor relief legislation. And so the Contracts Clause, which tends to foreclose that sort of thing, was the most important rights provision included in the original Constitution prior to ratification of the Bill of Rights. And as Professor Nilsson has told us, the Contract Clause was the Constitution's most frequently and litigated and enforced rights provision prior to the ratification of the 14th Amendment. So when we talk about the Contract Clause restricting debtor relief legislation, we're generally speaking of protecting contracts among private individuals or entities. The clause prevents the government from helping out one set of private parties, debtors, at the expense of another set of private parties, creditors, by restricting the debtor's obligation to pay off or restricting the creditor's remedies to enforce the deal. But Dartmouth College extended the Contract Clause to a different scenario entirely. As in its predecessor case of Fletcher versus Peck, Dartmouth College dealt with the state's own contracts, not contracts among private actors. But the state's contract in Fletcher was a simple deal to sell land, if you can call a fraudulent scheme to sell the entire states of Alabama and Mississippi a simple deal. The contract in Dartmouth College, on the other hand, was the college's charter itself. That is, it was an agreement that not only formalized a transaction, but it also created an institution. The Supreme Court's holding that the state of New Hampshire could not retroactively alter the terms of the charter established dear old Dartmouth's autonomy from government control. As Justice Bushrod Washington's concurrence put it, private and particular corporations for charity founded and endowed by private persons are subject to the private government of those who erect them. So you can't be much of a vox clamantis in deserto if the government is telling you what to cry out about. The court's holding ensured the college's ability to choose its own path without state interference on any number of issues of the day, how to respond to the evangelical tide of the Second Great Awakening, whether to remain an island of Federalist politics amidst a rising tide of Jeffersonian republicanism, whether to focus on a classical education heavy with dead languages or to teach more practical subjects like agricultural science. Vox Clementis and Deserto is pretty much all the Latin I know, but I'm glad we didn't become Dartmouth A&M. So, today, the college is free to be a critical voice in New Hampshire and national politics, an autonomous forum for debate during presidential campaigns, and an independent pioneer in the college's many fields of research and teaching. That independence is not solely because of Dartmouth College versus Woodward, but that case is the beginning of that story. My central point is that the autonomy that the Dartmouth College case conferred on the college is more than just the sum total of the individual liberties enjoyed by its students and faculty. By safeguarding the autonomy of private institutions of higher learning, the contract clause plays a structural role. My co-panelist, Professor Amar, wrote a long time ago about the many ways that constitutional provisions we generally think of as individual rights provisions also play vital structural roles in American constitutionalism. The Sixth and Seventh Amendments safeguard not only the individual rights of litigants to be judged by a jury of their peers, but also the structural role of the jury as a democratic check on judges and prosecutors. The Second Amendment protects not only an individual right to bear arms, but also the institution of the militia as a military check on centralized tyranny. The original understanding of the Establishment Clause, as Professor Amar has told you today, protected state establishments of religion against federal interference or a federal effort to establish a national church. So far, these examples are public institutions, the jury, the militia, the state church. These institutions aren't that different from the more familiar structures in this Constitution's separation of powers. But as Professor Amar also noted a long time ago, the Bill of Rights protects the autonomy of a number of private institutions that also play structural roles. The Press Clause of the First Amendment, for instance, protects the autonomy of the media as a vital check on both public and private power. The Speech Clause protects the rights not only of individuals, but also of the institutions they form in order to speak more effectively, like the NAACP or the Sierra Club or even political parties. The Religion Clauses, in conjunction, protect the autonomy of religious institutions that play pivotal roles in American public life, whether by political activity, good works, or simply offering an alternative example of a way of living. All of these institutions fall outside the governmental separation of powers, but they contribute to the broader checks and balances within American civil society. The Contracts Clause, as interpreted in Dartmouth College, falls squarely into this category of rights provisions with crucial structural implications. This structural aspect of the case is what may be lost in the movement from contract to due process that Professor Nelson talked about. Once the court found that the college charter was a protected contract, it asked only whether New Hampshire's law modifying that contract had changed the charter's terms and transferred power to govern the institution from the trustees to the state. It didn't ask whether the educational reforms that the state had taken control of the college to effect were reasonable or beneficial. As Professor Stith Cabranes demonstrated in an earlier work, they quite possibly were reasonable and beneficial. Contemporary contract clause doctrine, which is modeled in the Due Process Clause's deferential reasonableness test, would have asked precisely that question. One hopes that if the contemporary court confronts a contract clause case like Dartmouth College, where the question is state power to alter an agreement providing for an institution's basic autonomy, the only issue would be whether the challenged law meaningfully constrained that autonomy. It would not be whether what they were trying to do was reasonable in itself. This is what the court has done in analogous religion cases. In the Hosanna Tabor case, for instance, the court unanimously confirmed the ministerial exception, which guarantees religious institutions autonomy to choose whom they like to perform ministerial tasks without regard to the reasonableness of the constraints that the state might like to impose. The crucial point is that the movement from contract to due process in protecting contractual rights should not be allowed to obscure the clause's important role in protecting the autonomy of contractually created institutions. So I want to spend the remainder of my time talking about the importance of institutional autonomy for American politics and society. To do that, I want to turn to Alexis de Tocqueville's analysis of American society, which he published in 1835 and in 1840 at the close of the Marshall Court. Tocqueville thought that the dominant characteristic of American democracy was the widespread condition of equality among Americans. He did not overlook the glaring inequalities of slavery, but he focused on the absence in white society of the fixed social hierarchies associated with aristocracy and monarchy in Europe. So Tocqueville thought that American equality left us open to a particular danger, which he called individualism or democratic despotism. He worried that the tide of democratic equality had swept away all the old intermediary institutions that used to stand between the individual and the state: the aristocracy, the established church, the trade guilds and merchant guilds. Once this occurred, Tocqueville worried, the individual would find herself isolated from her fellows and unable to prevent the state's inexorable expansion. These concerns still echo in the work of contemporary social scientists like Robert Bellah and Robert Putnam. Tocqueville thought that the way out of this dilemma for egalitarian democracies lay in Americans' propensities to replace the old intermediary institutions with a wide array of decentralized political institutions, but also in especially private associations. These institutions and associations tended to pull individuals out of themselves and encourage them to combine and cooperate with their fellow citizens. And one might think of these civic institutions in terms of James Madison's extended sphere of the American Republic in Federalist 10, in which a greater variety of parties and interests competes, cooperates, and negotiates. Madison's extended sphere is inhabited not only by individuals, but also by groups and institutions. This grand mosh pit of clashing interests and institutions provides a filter and a check upon the selfish interests of particular factions, but it depends on the existence of a vibrant civil society full of varied intermediary institutions. Tocqueville gives us a lens to understand not only Federalist 10, but also Federalist 51, in which Madison talked about institutional checks and balances in the separation of powers. Federalist 51 focused on public institutions, the mutually checking prerogatives of Congress, the executive, the judiciary, and at the end of the essay, the states. But Tocqueville emphasized what Madison implicitly recognized in Federalist 10, which is that the structure of civil society itself is crucial in maintaining constitutional government. A civil society full of robust intermediary institutions helps prevent concentrations of power within the government, and it also keeps the government from crowding out and dominating the private sector. With apologies to my friend Heather Gerken, who wrote an article entitled "Federalism All the Way Down," we might call this separation of powers all the way out. So what does this have to do with the Dartmouth College case? I want to make both a general and a more narrow point. The broad point is that the constitutional order does not simply piggyback upon a pre-existing civil society. It helps to create and perpetuate that society by protecting the autonomy of private intermediary institutions like Dartmouth College. And as I've already noted, the Press Clause helps generate and preserve an independent fourth estate. The religion clauses help protect and encourage robust religious institutions, and the Dartmouth College case's construction of the contract clause helps protect robust intermediary institutions of higher education. As Judge Henry Friendly put it, one of the great contributions of the Dartmouth College decision was the impetus it gave to voluntary associations as a factor in American life. So the narrow point has to do with private colleges and universities in particular. Justice Harry Blackmun commented that I think it is clear that the decision provided a safeguard for the development of private education in this country. Many factors, of course, contributed to that. Modern divergences of public and private models of education probably didn't emerge until much later on. But Justice Blackmun was not wrong to suggest that Dartmouth College played an important role. For one thing, as Professor Eldon Johnson has put it, Dartmouth College produced a chilling effect on state intrusion into higher education governance anywhere, anytime. Nowadays, a variety of constitutional features, including not only the contract clause, but also the free speech clause, protecting academic freedom, the religion clauses, protecting the autonomy of sectarian universities and colleges, and the structure of American federalism. These have all brought about precisely the sort of robust and diverse civil society in the educational sphere that Tocqueville would have praised. American history or higher ed includes research institutions like MIT and Harvard, vibrant sectarian institutions like Notre Dame and Brigham Young, iconoclastic dissenting enclaves like Oberlin and Hillsdale, and even a few professional sports franchises. These varied institutional models are bound to produce a variety of perspectives and outputs, and it would be a mistake to leave out the state schools. Although New Hampshire played the heavy in Dartmouth College versus Woodward, states now constitute and contribute to the variety and decentralized structure of American higher education. So this robust educational constellation does, in fact, perform many of the functions that Tocqueville praised in American private associations. College and alumni communities do draw individuals out of their private lives and into community with their fellow members, often for decades after graduation. Colleges habituate individuals to serve others, and they train them to do that service effectively. They may be important participants in national political debates, as with affirmative action and gay rights, and their internal controversies train individuals to be effective participants in broader debates later on. All this is possible, I would submit, because the Constitution's rights provisions do not simply empower individuals, but they give rise to institutions playing structural roles. Characteristically, I'm going to end with a worry. Just as private institutions may play an important role in the separation of powers, broadly construed, so too that role can be undermined by the same sorts of forces that have undermined separation of powers in the public sphere. One thing plaguing contemporary constitutional theory, and making it a lot more interesting at the same time, is the need to revise our assumptions about how institutional checks and balances work in light of changes in the nature of American politics. And the principal change, of course, is increasingly high degrees of partisanship and ideological polarization. One can readily see how polarization undermines the effectiveness of other civil society institutions. Polarization has fragmented the media, for example, so that Americans of different ideological persuasions can pretty much choose their outlets, so they only hear what they want to hear already. Churches and other religious institutions have to some extent followed a similar path, and the increasing secularism of one party and defensiveness of the other threatens the ability of religious institutions to straddle and ameliorate ideological and political divides. One can see similar things happening to institutions of higher education. On the public side, the impression that public universities are far more liberal than the run of American society has led to attacks on the independence of those universities. This has happened both in my native Texas and in my current home of North Carolina. But the problem is not confined to public institutions. The perception and often the reality that public and private colleges and universities have taken sides in the partisan and ideology wars has hurt the credibility of academic voices in political and policy debates, and may in the long term prompt those who feel excluded by this side-taking to seek other educational models altogether. A related concern was voiced by our own Kate Stith-Cabranes at the 175th anniversary gathering. She pointed out that today the government's ability to circumscribe the autonomy of colleges and universities is less likely to take the form of direct legislative fiat and more likely to take the form of conditions attached to the receipt of government funds. These sorts of conditions have enabled national executive agencies under both the Obama and Trump administrations to try to induce important changes to university governance. I suspect that the tendency of educational institutions to take sides in the ideology wars has undermined their autonomy in these settings. It is commonplace of separation of powers scholarship, for instance, that partisan allegiances cause different institutions to be less interested in checking encroachment by the other branches when the same political party controls both branches. Partisan agreements may have a similar effect of causing universities to give up too much autonomy when intrusive measures curtail or dovetail with their own ideological convictions. If you like what the government is doing, you're less likely to fight it. On the other hand, forces seeking to intrude on university policy in less congenial ways may take arguments for institutional autonomy less seriously if they haven't been consistently advanced. So as Professor Stith-Cabranes acknowledged 25 years ago, it's hard to oppose intrusions on institutional autonomy when the measures in question seem substantively appealing. But structural values will not endure if we only defend them when they suit our substantive preferences. More fundamentally, it's important to recognize that much of the value of private intermediary institutions in civil society may stem from their ability, at least in theory, to straddle and ameliorate the divides that convulse the government sphere. Colleges and universities should be a place where people of varying views come together, and the formidable bonds of loyalty that places like dear old Dartmouth can generate ought to be a source of common ground. That will help us remember more generally that Americans who passionately disagree about this or that burning issue of the day nonetheless share important things in common. Thank you.
Okay, we have time for some questions. Not all at once? If people didn't hear him, could the presentations be made available? This is being taped by whom? The colleges, so I suppose there might be a stream of it somehow? Okay, yeah, they can make the files available.
Well, and some of these things will be published in the University of New Hampshire Law Review
Yeah.
in expanded form. Supposedly. There's many a slip
Supposedly.
between the cup and lip when you say, well, sure, I'll turn that into an article. But
Yeah.
it'll happen.
Someone-
Caleb had a lot of footnotes in his piece, so you didn't get you got one version, but I think it would be good to memorialize this, Caleb, so that we can check your footnotes.
Yes, yes.
I don't think mine will be published, but
Thank you for the great presentation. I came all the way from Arizona to hear this straight out of Dartmouth parent. But I wanted to make a remark about Professor Young's paper, very much appreciated. And it connected to some ideas yesterday, so the panel discussed this, that one of the principles of Marshall's reading the Constitution, and the story of the justices mostly agreeing, is the complexity of legal principles that check against majoritarianism. That there's space for majoritarianism in the American federal constitutional order, but there's also space for protecting against majoritarianism. The contract clause, not to mention, as Professor Muir had mentioned, the institution of the Supreme Court with a power of judicial and constitutional review would be one of those balances against majoritarianism. And that's a larger value of the Marshall Court ruling than the Dartmouth case and just general discussion.
Any comments?
One thing I would say, there was a lot of discussion yesterday.
People were suggesting that, he asked the panel to talk about the concept of protection against majoritarianism in the Constitution, and a limit on power of majorities, and is that a fair summary of what we're...
The tenor of the discussions yesterday about the idea of corporations having rights was generally negative, which I think is a fairly broad intuition, a fairly broadly shared intuition in American politics right now. But I think it's important to remember that the New York Times is a corporation, and the NAACP is a corporation, and the Sierra Club is a corporation. And these institutions help people come together and operate as checks on one another. And so I suspect the reaction to the notion of corporate rights more has to do with certain kinds of rights that corporations sometimes espouse, like freedom of contract that got in the way of progressive regulation of the economy in the early 20th century and the late 19th. And not so much, if we really think about it, with the very notion that sometimes we will treat artificial entities as rights-bearing entities in order to facilitate certain sorts of activity.
Why do you think that the founders focused on impairment of contractual rights when many of the founders, like Washington and Jefferson, had significant pre-revolutionary debt to the British creditors? Why would they focus on that as a particular call-out in the Constitution?
Why would the founders focus on debt, on contractual impairment, when so many of them had debt before, to British and Scottish factors before the Revolution?
This is incautious of me because I'm positioned between one of the world's experts on Jefferson and a professor at the University of Virginia. But by the time that the Philadelphia Convention met under the Treaty of Paris of 1783, the Treaty of Peace had already been signed, and it had certain adjustments of the debt that Americans owed to the British creditors. And basically what because during the Revolutionary War, Virginia had already kind of renounced certain kinds of debt, saying, pay whatever you supposedly owe to the British creditors to us, the Virginia government, and we'll deal with the British. And the Treaty of Paris said, if you've already done that, you're sort of free and clear vis-a-vis the British. Now the question is, had the Virginia, some debts had been paid to Virginia and others hadn't, and it's a question about when these things vested, in effect, very similar to the retroactivity themes that Caleb talked about. But Virginia had already passed some laws basically to escheat, to take all the claims that were owed to British creditors and say, actually, we, the Virginia government, claim all of those debts, and we'll settle up with Virginians. But as I said, maybe Annette and Caleb might want to jump in on that too, since they are experts on all things Jefferson and Virginian.
Well, Jefferson was in Paris when they did the Constitution, so he wasn't involved in that particular question. Do you have any more?
I agree with everything that has been said. I do think there were foreign policy implications to the Treaty of, so Article 4 of the Treaty of Peace did have the no lawful impediments to debts owed to British creditors. I forget the exact language of it, but there were, it could put the nation at risk of another war with Great Britain if you violate the treaty. That's actually one of the reasons for the Supremacy Clause of the Constitution. Why it includes treaties as part of the supreme law of the land is because the founders thought we don't want to have an individual state be able to provide a cause for war, and the collection of debts due to British creditors was a major foreign policy issue at the time of the founding, as Professor Amar indicated.
And in Virginia in particular, when the debt actually had been basically liquidated by the Virginia government was the real question of treaty rights, and the Virginia state government, the Supreme Court thought, the U.S. Supreme Court cheated on that. That's what gave rise to the litigation in Martin versus Hunter's Lessee, which I actually mentioned as one of the great Marshall Court opinions. It's all about Virginia debts and the precise moment of vesting, which is this. One other thing about Jefferson, every day he tallied up everything that he had listed, every expenditure, but he never added it up, ever.
Yeah. No double entry bookkeeping.
Justice Roberts has commented recently that his court doesn't have Democratic or Republican justices. I'm curious as to, in the period of time that the Dartmouth College case and the Marshall Court, were there similar criticisms, or did they consider themselves to be either Federalists or states' rightists?
For people, he asked a question about partisanship during the founding era. Justice Roberts said that there's no Democrat and Republicans on the Supreme Court. Did people have that view, or were there those problems during the founding era?
I think the best article on that is by Professor William Nelson in the Michigan Law Review about 30 years ago. Here's what's really interesting about John Marshall. He's a total Paul. He's never a judge before he's a justice, and he's a total political operative. And then he becomes the great John Marshall, who is appointed by a Federalist in the waning hours in a lame duck period after the Federalists have been defeated. And then the Jeffersons sweep in, and John Marshall, for the rest of his life, is going to have, on the court, he's going to have to deal with a court that's increasingly Jeffersonian, eventually kind of Jacksonian. And he manages, so he inherits a Federalist court, but increasingly it's a Jeffersonian court, and he creates this appearance of nonpartisanship. He's going to work with Joseph Story, who's actually appointed by Madison, who's a Jeffersonian president, and he's going to try to create a unified coalition with former Federalists and former Republicans, Jeffersonians, working together. That's his brilliance in the way that Earl Warren, who's a Republican who runs for the vice presidency, is going to be on a court with mainly Democrats and create a Warren court. And this is John Roberts' aspiration, whether it's the reality or not. But I do want to, because there's a lot of polarized voting on the Supreme Court. See Bush versus Gore. But in the most important case of his life, John Roberts, thinking a lot about John Marshall, sided with 4 Democratic appointees in the Obamacare litigation to uphold Barack Obama's trademark piece of legislation. That's interesting. Anthony Kennedy, a Republican appointee in several of the most important cases, has sided with Democratic appointees, the Obergefell case. There's a lot of political polarization, even on the court. I think I'd be not less than candid if I didn't say that. But I think the aspiration that all of the justices have is to rise above that, and often they do it. And even if they do it imperfectly, my own view is they do it far better than the other branches of government.
Well, and I would say about Marshall, too. I mean, he definitely controlled the court and worked with Story. He sort of brings Story over into his camp, much to Jefferson's chagrin, but he is following Federalist policy. Right, a nationalization and upholding the power of the federal government. So he's doing it perhaps in a way that looks nonpartisan, but he definitely has a political plan, and he's following the Federalists. Are Jefferson, vowed to sink them into an abyss from which they would never recover, and he did, the party, but the court remained, and Marshall exercise power from that domain.
Question for Professor Young. You were mentioning the increased partisanship and tribalism in our current politics. How do you see that impacting the effectiveness of the civil institutions you are also citing as checks and balances in our whole system?
Well, I think it's crucial.
Do you want to repeat the question first?
So the question is, as to what extent do partisanship and polarization undermine the effectiveness of civil institutions? And I think the hope is that institutions are able to be more than the sum of the preferences or the rights, the views of the individuals that make them up. Professor Amar said about the court is like that, right? It matters that it's a court and that it's a cohesive body that has to work together on an ongoing basis and that has certain internal rules about how it functions, which tends to moderate the partisan tendencies that people have before they get there. Now, it helped that John Marshall made them all live in the same house while they were in session and eat every meal with him, and so he could just work them constantly, right? Not all institutions are cohesive like that. And I think you still see institutions trying to do that. I'm a United Methodist, and last week the Methodists were really grappling with the question of same-sex marriage and how we're going to treat people of other sexual orientations within the denomination, and didn't seem to go all that well, but I think the strong effort was to stay together as a church, and there was an independent push for unity that came from the fact that it was an institution that everyone cared about its cohesion. Maybe it will split apart. I think that's what you're seeing in a lot of civil society institutions, but I think institutions like the Methodist Church that are able to straddle the political divide are essential if we're going to get past this period of intense partisanship. Because if we all just join our silo institutions where everybody agrees with us, and those are the only civil society institutions that we have, then I think we're done.
Sure.
Everything that Ernie said, here's one other additional hypothesis. There are advantages to sort of the combination of isolation and liquor. So John Marshall, these guys are away from their families, they're living together, and the Madeira flows freely. Here's what really impresses me about Dartmouth. So isolation plus liquor. And you guys are a purple state, and in a rural area. This is not New Haven. And what really actually impresses me very much whenever I come here is You've got liberal students and conservative students. That's not true at some of the other Ivy League schools. I'm being candid, and I'm always impressed by how the students actually across the political aisle. You have people coming up early in the Hampshire primary and late in the game because it's a swing state. And I think people here do a very good job, better than at a lot of the other Ivy League schools, actually, about talking across the ideological spectrum. And it's possible that beer and rum help in all of this. Who knows?
Oh, Harvard has conservative students. Maybe Yale doesn't?
No.
Harvard does. Harvard definitely does. So, did you ask a question before?
I just asked to have it published.
Okay. Well, let's go to him first. And I'll come back to you.
I lived, in spite of my accent, in England. The BBC has a duty of impartiality. Is there a role for restating the fairness doctrine, or is the splintering of the media rendered that irrelevant?
The media at the time of the founding were highly partisan. Benjamin Franklin Bache and the Aurora on one side, and Cobbett's Porcupine on the other, and that's freedom of speech and of the press, is the freedom to be partisan if one wants. I would say, in addition to freedom of speech, there's a duty to listen. And so what we as citizens have to do, we have to take special efforts to try to hear both sides. And it used to be easy because there was only Walter Cronkite, and he told us all that's the way it was, and we all got the same information flow. And now, as Ernie says, you can pick your information flow, but shame on you if you actually only choose to listen to the people, from one side. But that's up to us at the end, it seems to me.
Professor Amar, I just have a question about what you said about Chief Justice Roberts. In the Obamacare case, he took a very narrow view, in my mind, of the Commerce Clause, and was criticized by Justice Ginsburg, et cetera. Now, we have issues coming up, climate change and other things, that may require fairly strong federal action. What is Chief Justice Roberts going to do in that context after writing some of these decisions? I agree with you, he went with the taxing clause, but he went along with a Commerce Clause interpretation which constrains quite a bit his ability to be a conciliator.
I don't love everything in the opinion, but at the end of the day, he voted to uphold almost all of Obamacare, and he did so by joining with the liberals, and that was a lot. And the folks on his side of the aisle did not like all of that. It is important to give a shout out to the real architect of his idea, Robert's idea, to uphold the thing on the tax clause. His name is Neil Katyal. He's with us here. That's actually, his early briefing in lower courts. He thought the taxing power was a really important idea. I've always agreed with Neil about that. What's Roberts going to do in the next case? I hope he's going to listen to Neil in the next case the way he listened to Neil's early briefing in the Obamacare case.
I hope I will be able to articulate that question clearly enough, but it's for everyone on the panel. It seems to me that the fabric was sewn or being laid so that when the case came up for the emancipation of these slaves and giving the due rights to them and recognizing them as individuals, and therefore rights were being given and bestowed upon them, it seems to me that it was not intended for corporations to come along and piggyback on that so as to be viewed as an individual and also to receive those same rights. So those arguments for corporations should have had its own foundation. So if it's laid on a foundation that was not intended for, could it be a problem by the fabric seasons shed upon?
You didn't hear that? No. The idea, basically, you can tell me if I'm wrong, the summary, that the 14th Amendment, the Civil War, the 14th Amendment in particular, was about bringing black people who had been enslaved, into citizenship. Is there a problem with using that to make the claim that corporations are people individuals just like human beings, that they have a different focus, that the intent was different? And is there a problem with basing it on something that was not the original intent?
Well, I think there would be a problem if our assumption was we're just equating, we're anthropomorphizing corporations and saying they're people too. But I think the argument, and it tends to have been made as most powerfully in cases involving the NAACP, is that corporations can be an instrument by which individuals assert their rights more effectively. One of the most vicious aspects of Jim Crow was the extent to which it made it difficult for black people to organize in the South. And so NAACP versus Alabama, for instance, is a case recognizing the free speech right of the corporation not to have to turn over its membership list. Because if they turned over the list of the individuals who were members of the corporation, then the Klan would show up at their houses the next night. Right? And so it was important to say, if black people are going to be able to organize, they need to be able to do it in a corporate body, and that body needs to have certain rights to resist certain forms of government regulation. It's doubtful we could have an effective free press if the press wasn't allowed to incorporate. And it's getting easier to just be a blogger on your own, but I think there's still real advantages to having press institutions that are allowed to take the corporate form. Churches, the nastiest thing the federal government did to the Mormon Church was to eliminate the corporation that constituted that church, right? And that was an infringement of religious liberty because it made it much more difficult for that group to exercise their religious rights together. Mm-hmm. And so I think what we need to think really hard about is, when is that a compelling rationale for corporate assertion of rights, and when is it not a compelling rationale? Right? And there may be certain circumstances, there may be forms of regulation that are reasonable as to corporations that are not reasonable as to individuals, for instance. But I think it has to be a conversation kind of at that level of detail rather than just are corporations people too?
Mm-hmm. Unfortunately, we have run out of time. That's a very, very good question. I wish we had more time to deal with that. But thank you for coming.